It's another good day that we're discussing things law on the legal mind, and this is episode 7. My name is David Otieno, and today we are here with advocate of the High Court, specialized in labor and employment law, Wakili Makaya Oweya. We're going to focus on laws that were amended or enacted 2007, and it's going to give us direction, and we are here to stand guided because we don't know. It's the only one who knows. So we're going to discuss labor and employment, but we're going to focus on the termination of a contract, signing of a contract. Does contracts only applicable for the written one? Do we also have this one that you come work for me, I'll pay you? Hii mtu ameongea kwa mdomo, amesema wewe kuja kesho nifanyie kazi nitakulipa. So do we have oral contracts, or we only on the law only measures for the written contract? And again, termination. Most of the people their contracts are terminated. So what happened before the termination of your contract? Another thing, people are saying that there's another myth, and I don't know how I can put it, or it is a stereotype, that if you work for somebody for 2 days or 2 months, you automatically become an employer or an employee of that institution or that person. Is it true? Wakili is here to discuss and help us understand all these law on matters, labor and employment. Wakili, karibu sana.
Asante sana.
Yes.
Thank you very much.
Welcome to the Legal Mind. You are today featuring in episode 7. So tumefanya kazi sisi pia.
That's nice. That's nice. Congratulations.
Asante. The last time we met, we were in radio.
Yeah.
And I think we were still discussing the same thing,
We were talking about the same thing.
The same thing.
Yes.
Was it on law, on labor?
Matters employment.
Matters employment.
Yes.
Yeah. So I just want us to start, because I've introduced you. So does Kenyan's law also affect people who are Kenyans but are working outside? Can we start it from there?
Okay. So when you talk of the Kenyan law,
Yes.
it's what I would say territorial.
Yes.
That means it governs the relationship within Kenya.
Yes.
So if you are working outside Kenya,
Yes.
you will be guided by the laws of that particular country. Yeah. That notwithstanding, there could be some instances where if you come, let's say, as a diplomat or to that extent, you could be accorded some privileges by virtue of that particular position.
Yes.
But the general rule is that the Kenyan law will apply within the boundaries of Kenya.
Mm-hmm.
And when you are outside, you will be, in principle, guided by the laws of that particular country. An interesting thing will come if, let's say, I'm employed in Kenya.
Yes.
And my employer sends me for work outside Kenya.
Mm-hmm.
Now, you see, although I'm outside Kenya,
Yes.
I'm actually implementing a contract that was entered into in Kenya. Mm-hmm. And therefore, to some extent, there are some things, if they are to happen, although I'm outside Kenya and my rights are infringed, then I could come back and have a recourse within our Kenyan soil. So more or less, whether the law will apply outside the borders depends a lot on this kind of engagement that you are in. Yes.
That is perfect. I don't know whether I'm right or wrong, but when you look at our Constitution, Article 40, is it 41?
Yes.
That talks about the matters labor. Yes.
Yes.
You see in that the purpose of the Constitution were very clear on that anybody who's working for someone there must be engagement in a written form or maybe verbatively. So take us through this entire law, this Article 41, that is labor and employment. Take us through it.
Okay, so maybe before I go to the constitutional aspect of it,
yes,
you'll realize that our current regime of labor laws were enacted before the current constitution.
Absolutely, and that was...
And to some extent, I think the drafters of those labor laws and instruments had a foresight, because you find that there are some aspects they had already covered, which were later on engraved in the Constitution 2010.
Yes.
We no longer call it new. So and so what used to happen is what was enacted in 2007 was basically to give a framework. I normally say how the law works when things are not working. It gives a guidance now when this relationship isn't working. But if you look at those laws, they were framed with the employee in mind. For example, the Employment Act, even its preamble says it is meant to redefine the rights and the rights of an employee. It doesn't say the rights of the employer, but it says the rights of the employee.
Yes.
However,
Yes.
that also comes because of the power balance between the employer and the employee.
Yeah.
You see, with the unemployment rate and all that, it is seen that the employer appears to have an upper hand. I would say there are more people who are unemployed compared to employers who don't have employees.
Ah.
So the law was basically meant to have a balance, strike a balance,
Yes.
and also give the rights to the employees, as it were. And as it does so, every right has a corresponding obligation.
Yes.
So it also sets some obligations which the employee must meet, and also give some obligations to the employers, so to speak. And now coming to that, and if you look at the frame of the Constitution, I normally try to avoid reading Constitution with one clause, but I normally try to look at it because you'll find the Constitution as it is gives basically the framework. But even after that framework, you'll have other laws giving effect to that.
Yes, yes.
So, for example, the Constitution provides for labor rights, as you've said. But even much more important, the Constitution provides for dignity, rights to dignity,
yes,
and rights to social security.
yeah,
Now, in one way or another, all these are normally tied to employment.
yeah,
Because you find, for example, in social security, one major aspect that is talked about is retirement. And we say every employee should have a dignified retirement. After giving service all that time to the country,
yeah,
it's only fair that your sunset days are taken care of.
yes,
So you find that that aspect, the Constitution will say right to social security.
yes.
But then you will come down, and then there are specific instruments that give effect to those rights.
To that, yeah.
So, for example, I'll use that still as an example.
Yeah.
When you talk of right to social security, trickle down, you'll find we have retirement benefit laws
yes,
that now
yes, yes,
governs your retirement.
Yeah.
I mean, all these employment rights, it will be of no use we talk about them, and then they don't help you at the retirement stage.
Yes.
Still talking about that, you find still in the Constitution, they'll talk about fair hearing, right to be heard, and all those.
Yeah.
But then we have other instruments like the Fair Administrative Act, which now gives effect to this, and also that. So even as you talk for the labor rights as provided,
Yeah.
it gives the broader framework, and employment is tied to dignity. So all these frameworks and all these instruments have one goal: to ensure that there is dignity to the employee.
Yeah.
Actually, ideal situation is to give dignity to both. But because of that power shift and power balance, you find that its focus is more on the employee.
Yeah.
Yes.
Okay. So there's something that you've spoke about, that most of these labor laws, they were enacted in 2007 before we get the Constitution.
Yes.
But as a practicing advocate, do at any time see that there is imbalance between this act and the Constitution?
I wouldn't call it imbalance, because in any case that there's any contradiction, it is very clear that the Constitution will reign the day. It is the supreme law, so to speak.
Yes.
So there is no imbalance, so to speak. There could be some elements where they would appear to be clashing, but not imbalance. And then even because I know there's some particular section, for instance, that were deemed to be unconstitutional from the WIBA, Work Injury Benefits Act.
Yes.
I think that's a story for another day.
Absolutely.
So you find that whenever we can't call it an imbalance, because it's a question of what takes precedent. So if you look at that, although we have the employment laws, these laws are still under the Constitution, of Kenya.
Yes. Now, because you've also said that you don't just read an article the way it is in let's say Article 41, you read that then leave it. But when you look at these labor laws, it ties between Article 27, it goes to Article 29, it goes all the way. It is not only one article.
Yes.
How does now this law relate to Article 27, whereby you should not be subjected to any form of discrimination?
Yes, and if you remember what I've said, I've talked about
Yes.
having dignity.
Dignity, absolutely, yeah.
One aspect of dignity
Yes.
is that you should not be discriminated on any ground, so to speak. You know, like if there is an opportunity, let it all be fair and square. But then again, Article 27 talks of discrimination as it is.
Yes.
But in the context of employment, sometimes discrimination needs to be understood differently
Yes.
from what I would call something like differentiation. And I would say, and you see, we have things like affirmative action.
Yes.
You know, those
Yes.
things.
Yes.
And they are interpreted to be different from discrimination, so to speak.
Put it
Now-
into context. We'll give an example. So that we
I'll
can
give you
understand.
an example.
Yes.
In the recent recruitment of judges,
Yes.
if you go through all those recruitment,
Yes.
the first question is normally after introduction, they ask you, can you tell us your county and ethnicity?
Yes.
So, I mean, from a pedestrian look at it, you could wonder, why would my ethnicity matter in such a forum? You know,
Yes.
but then they'll tell you, and in fact, they'll ask you, you understand why we ask you that. And most of that is because, again, the same constitution that says you shouldn't discriminate provides for inclusivity.
Yes.
You know, so inclusivity says that you have to look at broader aspects, so that even as recruitment is done, there are some aspects that have to be considered, which without looking keenly would in other places or in other times be considered discrimination.
Okay.
So you find that you'll be asked as JSC, tell us your ethnicity, tell us your county, and that is because they also want to achieve another tenet that is provided in the Constitution, that is inclusivity. You know.
So let me put it down. Let me note it down as a layman to understand in this context that, let's say, for example, you are looking for judges in the Supreme Court,
Yes.
and perhaps David is a Luo,
Yes.
and let's say another candidate, Ibrahim, maybe he shares a name with the Christian, but he's a Muslim and coming from other part of Kenya, and David comes from another part of Kenya.
Yes.
So in this inclusivity, this bench must also include other people from other areas.
Yes.
So it is not part of just knowing David as a Luo to be discriminated for getting that opportunity. It is a matter of including David in this bench and another person from far end, and most importantly, the people from marginalized community.
Yes.
So
And
that is the
for,
idea.
It is for a good cause.
Yes.
Marginalized community is just but one aspect of it. For example,
Yes.
and again, allow me to use the same example I gave of the JSC.
Yes.
They've recently appointed Judge Warsame.
Yes.
And he's going to replace, I believe, Judge Ibrahim.
Yes.
Now, if you look at that, that's the apex court in the country. Any dispute that might, once it finds itself there, it's likely to go anywhere else. Whatever comes from that court forms precedent.
Yes.
Now, Kenya as a society is comprised of people from different walks. And in this context, I'll say, let's use religion just as an example. We find that even we have different judicial systems for different religions. And I'll use the Qadi court as an example.
Yeah.
And sometimes the disputes from the Qadi's court will go and find their way to the
Supreme Court. Yes.
Now, tell me, even for the practicing Muslim practice and people, if an issue touching for such an aspect is to be adjudicated by the apex court, which has 7 people and none of them professes that particular religion, doesn't matter the outcome, from the outside look, it appears as if the people adjudicating have no clue on what they are talking about. But if you have someone there
Yes.
who professes that faith,
Yes.
there is some faith in that outcome of that, because you'll say, at least this person is there to guide them. This works this way. So if you look at it, it's
Yes.
not only about marginalized community,
Yes.
but there are other aspects that come into play.
that will be considered before that.
Yes.
But now a Corino can also say, because we also have our own way of doing our things, we also need a Corino in that bench.
Now, that is also one way to look at it, but I was giving as an example. Because if you look at it, we only have 7 judges there.
Yes.
All the 47 counties
Yes.
cannot give a representative to that court. But there need to be some semblance of a balance.
Yes.
And if you look, again, using your example of a Corino,
Yes.
a Corino don't have an equivalent of Kadhi's court.
Oh.
So within the Kenyan judicial system,
Yes.
they could only come in and be considered an aspect of the, we call it alternative justice system. But not, I mean, you see the Kadhi court is duly formalized, it is in the constitution and all that. So it's a bit different.
I think law is very wide in a manner that you can't just read and understand the content in it without getting the context of the framers.
I normally say for any law to apply, 3 C's must be considered. That is the concept, and then the content, and then the context.
So you must have the 3 C's.
Yes. So for example, I would say, like, as a concept, everyone should be treated equally.
Yes.
Like, you don't need to have it in a constitution. Like, as a human being, you should just treat everyone,
yes,
I mean, equally and fairly.
Yes.
That is the larger concept. But then I've seen, this is your favorite article, Article 27.
Yes.
Now makes it a content. It has it written down. It is coded. So now it is content. It is a content you can access from Article 27. And then as you read that concept as presented in that content,
yes,
you need to now apply the context. And now that context is when now you and your other colleague Ibrahim, who are coming for that position,
yes,
now we have to look at the wider context, not just what the content says.
Perfect. Well, and I think the same can also apply to the spiritual books, because if you just read them the way you want, they will advise you to take alcohol.
I will not comment there. I'll not go. But I have a friend who normally says,
yes,
even as you read the spiritual books,
yes,
you should be alive of the difference in time from when they were written and when you are reading them.
Okay. Sasa, allow us now to concentrate on this, the elephant in the room. Now the labor laws. And I think you've explained it better and how it works. And maybe perhaps why was it important for the framers of the Constitution or people alongside or people working in that environment think that before I work for Makaya, I must have something that ties us, like a contract. Why was it important for one to have a contract? And before signing a contract, what should one consider as an employee?
I normally say the thing about contracts, and not just employment, is sometimes you write them or enter into them not knowing when you will need them, especially the clauses. So as the issue is that there are rights that have been provided for. And like I said, with every right comes an obligation. Now, there's normally need to create boundaries in terms of what are my obligations, and should I do more? What should I expect? Should I do less? Maybe not meet your expectations. What should I expect? And now for employment law is to basically govern and provide that particular framework. And allow me to also say this. One thing that I think even the courts have recognized is that even the law that we have, they are not comprehensive. They don't cover everything.
Yeah.
And now that has given room
Mhm.
for people to have policies and even procedure manuals. Now, here's normally a very important part.
Yeah.
And sometimes employees are given contracts. They'll read the contract from A to Z, but they fail to read the policies and procedure manuals. Now, on the flip side, sometimes employers will also have contracts, policies, and procedure manuals. They'll do everything as per the contract and forget to do the most important things as provided in the policy manuals. Now, these policies, the court usually also recognize them to be part and parcel of that particular contract. So even as you're entering into any employment contract, you should make it a point to also familiarize with these policies and procedure manuals. Like they normally say, the devil is in the details. So sometimes you'll find you're given a 1 or 2 page employment contract, but you've not read the 150 page procedure.
Yes.
So if something happens later, is when now you are given a clause from the procedure manuals, and maybe you'll be seeing it for the first time. And now, in some instances, it's even worse because unless you're given this policy and procedure manual, you may not even know that it exists. In case a dispute arises and you file it in court, you'll be seeing it for the first time as the employer's documents. And sometimes it's interesting because you'll find even instances an employee will say they've never seen such a document, but then their signature is there.
Wow.
And then you ask them, so what happened? And then they say, we were just given a bunch of documents to sign. I know sometimes it comes with the excitements of getting a new job and all that.
Yeah.
You want to finish with the papers.
I remember myself. I just read how much, terms and conditions, then signed. I didn't go further. Nalipwa ngapi, nafanya kazi gani, namaliza saa ngapi, natoka saa ngapi, signed. Because it is big and the font are small.
Yes.
We don't have that time.
The devil is always in those details. So, and this is, I'm saying, this is not just for employment contracts alone.
Yes.
Any contract, try to read it as much as possible. Now, the most important aspects, which I normally say someone should read, is I know there is the how much part. I think that one I don't need to tell anyone. But the thing I normally say we need to look at is the obligations that you're being given vis-a-vis the expectation that the other party expects from having you.
Yeah.
That is normally very important because you'll find most termination come normally as a part of breach or alleged breach of the obligations that you're being given. Now, if you are not familiar with what obligations you're entering into, a problem comes when it comes to you delivering. Because you don't appreciate what is expected of you, chances of you not delivering are also very high. Then also with that obligation, and you're able to know what does that particular employer expect from you. And something else, and it sounds like something that is not serious, but it happens.
Yes.
People sign contracts and they do not retain copies of those contracts.
Wow.
So if someone tells you, yes, I was employed, they gave me 2 copies and I signed and I left them with the manager.
Wow. What is the danger of that?
That exposes you so much because assuming you've worked for 4 years, you sure cannot remember in detail what you signed, each and every detail, what it provides. I know what people normally remember is how much they're paid, the number of leave days, and maybe if there's promotion and all that. But then sometimes, like I say, the obligations part is everything, because it is what will decide when to stop and when to say you need to go harder, because you know what is expected of you. Now, worst case scenario is if you are dealing with someone that is rogue. If you signed at page 4, they literally have the power to alter page 1, 2, and 3. You don't have a copy.
Oh,
So, something like that.
so they can give you a contract of 4 pages, separate pages.
Yes.
Then they send you this contract, then you sign, you leave them with all the documents without having a copy of the contract that you've signed. And then later on, they change at least 2 pages.
Yes.
So you are not privy to what in these 2 pages that have been changed.
Yes. You think
they-
you are a supervisor, kumbe you are not.
And then now, when they terminate your contract pursuant to the reasons, now they can bring this new contract to you because it's going to be new in your face, and tells you this is what you signed for. And because you didn't recover or obtain the first contract, now you are left in a dilemma.
Yeah, because mostly when you're in court, it's a question of evidence. So you say you employed this. What do you have to support that? They'll bring whatever contract they have. And mostly that one comes especially for that salary aspect. Or let me even give a very common example.
Yes.
You are employed, you are earning 50,000.
Yes.
The contract you have reads 50,000.
Yes.
But in between, you've had some salary increases. You see? And now, unless it is coded in a payslip or something like that, because whenever there's a dispute and you take it to court,
Yes.
if you allege, this is my salary, it is upon you to prove. They normally say whoever alleges must prove.
Burden of proof lies.
Because I've seen a scenario where
Yes.
someone was being paid, I think it was around 45,000.
Yes.
But the contract they had signed said he was being paid 16,000. Yes. So when you ask him, so what can you show? And then they were not being given pay slips.
Yes.
They used to sign vouchers. And then now when they sign those vouchers, they leave all the copies
With the office,
with the employer.
with the employers.
Yes. Sometimes we have these organizations that have email with their company domain.
Yes.
And sometimes it's nice. They send you all this information. But remember, the day you're fired, the first thing they do is they
delete.
lock you from that email. So you'll say, this information is there, and it is in my email. Then which email it is? That's when you realize that was not your email.
So, as an advocate, I think you've practiced this for so long. I have 2 questions. Is it a crime for me to sign 16,000, yet I'm receiving 40,000? That is 1. 2, if at all I have been signed with a company domain, and then now after being fired or my contract terminated, they log me out. Yeah. Can I compel the court to at least give them direction to get me back so that I can have my evidence?
So let's start with the first one.
Yes.
You've signed for 16, but you're being paid 45.
Yes.
There's nothing wrong with that. But like I'm telling you now, if you are, the problem comes when there is a dispute. You see, when there's a dispute,
yes,
and you claim you're being paid 45, like I told you, whoever alleges must prove.
Must prove, yes.
So remember, it is your right to have a copy of that contract. It is your right to have a copy of your payslip whenever you're paid.
Yes.
It is, and it can be in any form, because the law calls it a statement of what you're being paid and the period of which it is, if it is monthly, if it is weekly. So it is your right. But the thing is, if you sign the contract, and even if you have a copy, and then here you are, you're being given 45, and then there's no document supporting this 45, if a dispute arises, that person can, I've seen this in many court cases where if an employee files a case, the first line of defense by the employer is that they deny everything you have stated in your claim, except for what they have expressly admitted.
Yes.
And I guarantee you, they are going to admit very little. So it is for you to, even when you have the best employer or the person you think is the best employer ever, it is normally for you to also be proactive, especially when it comes on your rights. They normally say if you sleep on your rights will slip away from you. So you need to ensure that this is information that you have and you keep, because it comes handy when you least expect.
Okay, that is good. And I think this context, we're just discussing the written document, which is very important.
Yes.
I think a take home is one, ensure you remain with a copy of our contract. Number two, before you sign that contract, please read it. And this question goes to you directly. Should I or any other person seek a legal, let's say, a legal advice before he signs a contract? You tell the company, okay, give me the contract I go with, I'll read it with my lawyer, or my lawyer will assist me to understand it better, and then I'll bring the copy tomorrow. Is it important for one to sign a contract under the guidance of his or her lawyer?
I think not just employment again. It is normally important to seek guidance whenever you're signing any contract, because any contract creates legal obligation. Now, the only person who can help you understand your legal obligation is
the advocate.
Yes, there's normally a meme that goes around among us lawyers. They say, if your car is broken, you take it to a mechanic.
Yes.
If you feel unwell, you go to a doctor.
Yes.
But if you go to a lawyer, you'll first go to ChatGPT first before going to. So that's that small act of taking that contract through a lawyer,
yes,
can save you a lot.
Can save you big time.
Can save you big time. Okay. And also one aspect which I didn't mention when I was talking that is exit.
The exit now.
Yes.
Yes.
How do you exit from that employment arrangement is also very important.
But I think for an employee, you can just wake up very early in the morning and tell the employer, oh, now I'm sick, I need to rest, and maybe I might not come back, please find someone.
So then that's why I'm saying it is normally very important to understand what the contract provides when it comes to exit. Because sometimes you could find yourself in an employment engagement which says that when you leave that company, you will not work with another company that provides similar services within a radius of, let's say, 500 kilometers for a period of 5 years. They are normally called non-compete clauses. So sometimes they're important because if the employer is equipping you with some very unique knowledge, they would want to protect, they call it the intellectual property and all that. And, now sometimes when you're entering this contract, there's some level of excitement which you have. And like I said, you look at how much from when.
Yes.
But the important part sometimes in any engagement is, how do I get out? Because you could say get out, they could say they want a 6-month notice. So again, it depends with the kind of work that you are entering into. So a 6-month notice, if you are seeking employment elsewhere, which employer will wait for you 6 months to serve that notice before you come?
No.
And now, if it is such a notice, and then you're told you should pay that employer equivalent of 6 months before you leave, again, it exposes you financially. So it is normally very important to understand the mode of exit and even the mode of dispute resolution that is provided for.
Okay.
And there are some different forms of alternative dispute resolutions that are there. And sometimes they are provided in the contract. Let's say, for example, if a contract provides for arbitration and another one just says conciliation. Let me just use these two forms of ADR. just to expound further.
Yes.
Now, the conciliation contemplated in the Employment Act is a very interesting one. It says that if you're going through that conciliation process, sometimes advocates are not required to go and represent anyone before that particular process. So sometimes if you're going against a big organization, that big organization, most likely than not, they have an internal counsel. They have an in-house counsel. So you find from the outset, they have the benefit of getting the legal counsel, legal advice they need.
Yes.
Now, this other side, when it says conciliation, it will be you. And then if you go with the advocate, and it is a very, I don't know why lawyers have not challenged that law. I think we'll find a way to.
Okay.
So you
Yes.
find that
Yes.
there are some contracts that, no one say they're like prison. It's very easy to enter, but then coming out
It's difficult.
is a different story altogether.
Okay. In the same content, I think most of the employees feel that when they give a notice of exit, they might face frustration in the organization. And perhaps there's something that you spoke about. The exit plan is you need to give a notice for about 6 months, and then who will wait for you for those 6 months?
Yes.
I think nobody will. So what are the consequences? Perhaps all these consequences are under the obligation of the contract that you signed minus reading it keenly, or under the law. What is now the consequence when an employee exit an employment when I exit the employment firm or in my firm nimetoka tu bila kujulisha, bila kufuata taratibu ambazo zinahitajika, so mimi adhabu yangu inakuwa ni gani?
Okay. So the nature of penalties, consequences,
Yes.
is something that should ordinarily be provided for in that particular contract.
Yes.
Now, where it is silent, the courts have normally taken the view that, let me start with the employer.
Yes.
If the employer is to terminate an employee's employment without notice, there's something that is called payment in lieu of notice. So that means if the notice period provided was 1 month, then they'll pay you 1 month equivalent. If the notice period was 3 months, they'll pay you 3 months. Now, on the flip side, the same applies to you as an employee.
Yes.
If you are to quit employment without notice, then the law would require you to pay in lieu of that notice. So if you left and you are required to give 1 month notice, legally, you're also supposed to pay the employer 1 month salary.
Kwani, why should I pay the employer and I am being paid for work done?
Yes.
Why?
Like first, you are breaching a contract.
Oh.
You are breaching
a contract.
Yes. And one aspect is, even from a commercial aspect, if you just leave without such a notice, there's some level of inconvenience that you're going to cause that particular employer and all that. So it is meant to protect both sides. It is meant to protect both sides.
Yes. So take me through, what are the factors that the employer must consider before terminating my contract?
Okay, so that one usually depends on the nature of engagement that you have. But in principle,
yes.
Before, let me go back to that notice part.
Yes.
Here's the interesting part. As an employee, you can terminate that engagement without giving any reasons. All you need to give is, if it is a notice period, serve your notice period, or if you can, pay whatever amount you're supposed to pay in lieu of that notice. The employer, unfortunately or fortunately, does not have that luxury. No employer is allowed to terminate an employee's employment without giving reasons. So they have to give reasons, and the reasons must be valid. So when it comes to terminating employment, the court will normally look at it from two broad perspectives. There's the procedural aspect,
Yes.
and then there's the substantive aspect. Now,
Yes.
the procedural aspect is usually, especially when now it is a contentious termination,
Yes.
where it is not a voluntary or mutual separation. Now, there are some processes which an employee must be taken through.
Yes.
And the first one is that if, let's say, if it is termination on account of breach by the employee. So if they've done something that the company considers that it is not proper or what have you. So the first aspect is to inform the employee of that particular breach. And it is normally done in form of what we call a notice to show cause. So a notice to show cause will essentially state what you have done in contrary to the contract you had or in contrary to the policy that exists. So it will, and it has to give you in details, and it will give you some time to respond. Now, the law says they need to give you reasonable time. What is reasonable time? Now, reasonable time, I think it is, it was intentional not to give specific number of days or anything, because it depends with probably the nature of work that you're doing and all that. But what the court will not allow is a short period, an unreasonably short period, so to speak.
Okay.
And this again, like I said, it is tied now to fair administrative actions as provided in the Constitution and
yes.
the Act, as well as right to fair trial or fair hearing.
Yes.
So that aspect, when you're given that notice to show cause, in some companies, they give it in form of what they'll refer to a charge sheet, stating what charge they are leveling against you. It could be because, let's say, someone came late to work, came late and drunk. And nowadays they say being drunk alone is not a problem. You should be drunk to a level that you are incapable of doing the job you are doing. So they need to tell you on this particular date, this is what was expected of you, and this is what you have done. So the company gives you, let's say, 7 days to respond. Now, you as an employee, remember you have a right to fair administrative action.
Yes.
You have a right to a fair hearing.
A fair hearing, yeah.
And I normally say every right is accompanied by an obligation.
Yes.
So in exercise of your right to fair hearing and all that, your obligation comes. You have to respond to that particular show cause letter that has been given to you. So you put in your response. It is preferred because the law says that the employer has to state in writing. So since they're stating for you the breach in writing, it is also upon you to respond in writing. So once you give them that response, it is for the employer now to look at whatever explanation you've given. Does it make sense? Does it hold water? Is it reasonable? If it is reasonable, they may choose to stop it from there and let it slide. If whatever explanation you've given is not sufficient according to them, the next thing they are going to do is to give you another letter inviting you now for what we call a disciplinary hearing.
Yes.
Now, ideally, again, they need to give you time to prepare for this process. So they cannot tell you, for example, David, we need you to come tomorrow morning.
Yeah.
No, they need to give you time. Courts have declared 2 days as insufficient time. So we are looking at, let's say 1 week again.
1 week, yeah.
For you to prepare,
Yes.
and so that you can prepare your defense.
Yes.
Now, in these hearings, you are normally allowed to also bring your witnesses if you feel they're going to add value. You have a right to be given any documentation that is going to be used against you. Let's say, for example, it's an issue of theft.
Yes.
A theft occurred in a company, and then the DCI were involved,
Yes.
and then the DCI later gave a report to the company. And then this report is the one being used to
Against
condemn
you.
you.
Yes.
It is as a matter of right. And this right is that whether you ask for it or not, they're supposed to give it to you. Now, when you're given, whether you read it or not, now that's up to you. But if you want to exercise your right, then the obligation to read it comes with it.
Yes.
So now, where are we? You've been given 7 days to prepare. Now, 7 days have lapsed. Now we're on that hearing. Now, what matters is in that hearing, the composition of the panelists that are adjudicating your issue matters. Let's say, for example, I cannot have been the one who have complained against your actions, and then I'm the one seated there adjudicating on your disciplinary
yes.
hearing. You know, so it has to be people who are considered to some degree independent, have no interest or connection with whatever matter or dispute that is being adjudicated on.
So I think in that, then the employee is being protected more than the employer, but you've stated earlier the reason behind that.
Yes.
And then again, apart from that termination of a contract, can somebody be subjected to a compulsory leave and then be achishe tu kazi na employment na employer? What happens when someone has been subjected to a compulsory leave? What should follow after that?
So the issue of compulsory leave, I think when you're being put on compulsory leave, what matters first is it paid leave? I mean, if I'm working, I wouldn't mind going on compulsory leave that is being paid. So the thing is,
yes,
is it compulsory leave with pay or without pay? What does the policy say?
Yes.
Then for how long is this? Because sometimes an incident may occur at work.
Yes.
This incident might require some investigation to be done.
Yes.
Now, your presence in that office may hinder that particular investigation.
Yes. Yes.
So it is only fair that at least you take some time off as this investigation is done.
Yes.
But now a question comes, how long will you be on that compulsory leave? Remember, when you're on compulsory leave, in some extent, you're still tied to that employer.
Yes.
That means you can't take up another role. You know, you are still employed, so to speak.
Yes.
So they shouldn't keep you out for a very long time. You could be sent on compulsory leave for 2 weeks. Then they finish the investigations. Then from the investigation now they say, kuna mashtaka ya kujibu. See, that makes sense. But then they could send you away, and later on, while you are still on leave, you get your termination while on leave. That is wrong in all aspects.
And
that is wrong in all aspects.
In this, let's say, for example, you have been subjected to that for 3 months, 90 days, pending investigation, then the 90 days collapse. There is no communication, nothing. But you can see in your area of work, somebody has replaced you. So do you see it as a way of terminating the contract indirectly? And what are the legal channels that one as an employee should take so that he can get his right back?
Okay. So remember when I said the issue of employment is also tied to dignity.
Yes.
So that now sometimes you can have a position like that. Let's say you've been sent on that compulsory leave. The leave, let's say it's 30 days.
Yes.
It's done.
Yes.
And you've been brought back to work. But then where you are serving, there's somebody else who is doing your job. So in essence, you are basically, for lack of better word, doing nothing. You come in the morning, you are given, let's say you even have your office back.
Yes.
Come in the morning, you're given a newspaper, nice tea, but there's no file, no work that is coming to your desk.
Yeah.
So in essence, even if they're paying you, even when they're paying you, but you see now, you're not doing anything. So there's the concept called constructive dismissal. So in constructive dismissal, it is basically the employer acting in a manner that either makes it impossible for you to work or renders you are just there and not being able to perform any job. And that's why I say even the aspect of you getting to work and getting employed for work is something that is tied to dignity. So for you, when you just come there and there's nothing, even you will start complaining.
Yes,
Naendanga
yes,
tu
yes.
hapo na hakuna kitu mimi
Nakula
nafanya.
lunch lakini yeah.
So that one is
Yes.
in itself an aspect in constructive dismissal.
Dismissal,
And
yeah.
do you know why? When someone is paying you and they're not giving you duties, unajua watakushikia wapi? Performance appraisal.
Na mkubwa si wewe ndio hukunipea kazi ya kufanya bwana.
You see now that cannot. So you'll be happy. You could be happy maybe. You
Yes.
go there, yes, read newspapers, enjoy. But remember, there's that performance appraisal.
Appraisal, yeah.
Where now, now, you know, some offices, it's purely based on output. How many how many containers did you process? You see now you love that answer as a chorus. Ni wewe hukunipea kazi. How many did you? Ni wewe hukunipea kazi.
So what were you doing?
Ni wewe hukunipea kazi.
Yes.
How do you want it? But you see now, it is not your own doing. It is the employer's doing. That's why we are calling it, he was firing you without telling you.
And then I think you've put it very clear. We've gotten the concept. We also got the context and now the content. Huh? So let's talk about this as we wind up. The issue of this contract that somebody's been given. When I was coming here before the set, one of the bosses here asked me that there is a law which says if somebody pays you 2 consecutive months, then that is rendered as this person is your employer and you are his employee or employee. So how does this work? Do we only have a written contract, or we can also have the verbal one, oral one? Can we just come and agree, David, from tomorrow, come and fetch water for my wife? I'll be paying you 30 bob per jerrycan. And then we don't agree on any other thing. Maybe you're paying me on cash or M-Pesa. Can that one ties us as an employer and an employee?
Okay.
Yes.
So I think for a broader appreciation of it,
yes,
maybe we're looking at forms, nature of employment. Now, there is what is normally called a contract of service and a contract for service. Now, there is employment, and then there is what we would call an independent contract. That is just but one way of categorizing it. For example, like the one that you said, David, come fetch water. Now, depending on the arrangement, you could be treated that you and the water you are fetching, you're basically an independent contractor and not an employee. Such that where I sit, all I need is for you to find your own ways and deliver that water to me. Whether you deliver it by mkokoteni and it hurts you somewhere else, that is not my problem. But then there is the same thing. I could be having my house manager. I'm sending him to fetch water from the same place you fetch. Then ameanguka na mtungi. Now that is my employee. I'm liable. So that level and aspect of it matters. Whether you are actually employed or you are just offering a service as an independent contract.
Yes.
And it sometimes some cheeky employers would give you a written contract for service. Here you'll sign it, not knowing that it should be contract of service. So, but then even the court sometimes is aware that there could be this cheekiness, and therefore what matters is the degree. They look at some tests, the degree of control, and all that, whether you are actually independent or employed.
Oh,
now we get done.
So
with
which
that.
one is for independent? Contract of service or contract? The other one you call contract for service. Yes.
For service.
So which one is for employment? Which one is for self independent?
Contract of service is employment. Contract for service now is you rendering your services as an independent contract. Something you've said is now, again, there's something we call short-term contracts. and there are short-term contracts, and then there are contracts that are based on whatever purpose there is.
Mm.
So let me say there's some construction going on,
Yes.
and we project that this construction will end in 2 months.
Mm.
So you are given a 2-month contract.
Yes.
So it doesn't matter if you're paid 1 month, the second month,
Mm.
you cannot become now a permanent employee.
Ah.
But there's something that probably I should clarify. Previously, there was this habit of having people as casuals
Yes.
for a very long time.
Mm.
So you just have them as casuals
Mhm.
so that you deny them some very important benefits.
Mm.
So you'd find somebody is been there for 2 years, but is a
As
casual,
a casual
employee,
laborer. Yeah.
laborer, so to speak.
Yes.
So the law was not impressed with this, most of the courts,
Mm.
because the courts felt that this is now an unfair labor practice.
Mm.
So what was considered is probably if you were in that engagement continuously for a certain period, let's say 6 months,
Mm.
then you could be deemed to have been fully employed and
Mm.
not a casual laborer, so to speak.
But again, how will I explain myself that now I should be entitled for the benefit of maybe retirement, that package now, because maybe I have worked for 5 consecutive years, or they are going to accumulate from first month to the
So depending on the period you've served,
yes,
the benefits that would arise
yes.
would be from the first time you started working.
So
Yes.
there is not going to be difficulties.
Yes.
And again, this is very important. The benefit of retirement is not only for the people who are above 60s. You can retire as 40.
Retire. I don't know if the word would be retire, but can quit employment at any age.
Let's use that word quitting.
Because the reason I'm saying so,
Yes.
and unless you are speaking retirement,
Yes.
just as an open word, not retire as a legal concept.
As a legal concept of 60, no, not as a legal concept.
Because
Maybe I am employed by National Youth Service. After 20 years, I say, no, this is now, let me seek for early retirement.
Yes.
Yes.
If retirement, you can, I mean, that's how you're looking at it,
Yes.
then that's okay. I mean, you can do it at any given time.
Mm.
But I need to tell you,
Yes.
retirement and the law governing retirement
Yes.
is a totally different regime, such that,
Mm.
let's say you've worked for 20 years
Mm.
and you still have 30 more years to work for, and you decide now I want to call it quits.
Mm.
You cannot access the entire retirement package, especially if it is saved as a pension. You can only get, I believe, half of it.
Half of it.
And the law changed to half of it.
Oh, interesting. We are going to discuss that in the next episode, God willing. But for now, Caro is telling me as the producer, David, our 1 hour is done. And we should be away from the office. Thank you so much, Wakili, for coming. But as you wrap up,
Always a pleasure.
you are parting short. Caro told you to look at this camera. That is the opportunity for you to use this camera. And tell Kenyans something.
Okay, Kenyan something. But just to say, with respect to those employment contracts and any other contract, just treat it the way you treat your body. If you feel unwell, you take it to the hospital. If you find that contract, run it through a legal expert. It will save you a lot.
I cannot speak when my senior has spoken. I was to call you my learned friend, but I learned that I've never been to Kenya School of Law, so I am not qualified. Thank you so much for watching the 7th episode with Wakili Makaya Oweya. I think it was fantastic. I have learned a lot. This affected me big time. I only read how much, when to start. In fact, I was to start on 14th of October. I cannot forget. Thank you so much.
Thank you.